Picture this. You are in the middle of a serious dispute. It could be a business deal gone horribly wrong, or a contractor trying to pull a fast one on a home renovation, or maybe something even more personal.
Right.
The tension is high. The stakes are very real, but you aren't sweating it. Why? Because you have the ultimate smoking gun right there in your pocket.
You've got the WhatsApp chat.
Exactly. You have the chat, you scroll back to that exact conversation, you take a quick screenshot, and you just sit back with a smirk.
As far as you're concerned, the case is closed. You have the proof. But here is the million-dollar question. Do you really?
Yeah, that is the big one.
Is that screenshot actually the ironclad evidence you think it have, or did you just bring a water gun to a legal firefight?
That illusion of security is, it's something almost everyone operates under today. I mean, we treat our phone screens like gospel truth.
We really do. If we see it in a little green or blue bubble, we just assume a judge will look at it the exact same way. But in the eyes of the law, a simple screenshot is literally just a collection of pixels. It means almost nothing until it passes through a highly rigorous, intensely skeptical set of legal filters.
And that is exactly our mission for today's deep dive. We're going to unpack the complex and, frankly, quite surprising reality of how a simple text message on your phone actually becomes admissible, court-recognized legal evidence.
It's a fascinating journey.
It is. We are looking at a really incredible set of sources today. It's a comprehensive comparative legal analysis complete with visual guides, actually compiled and edited by advocate Usman. He has mapped out the digital evidence laws across 4 major jurisdictions. We're talking India, Pakistan, the United Kingdom, and the United States.
And it's a brilliant compilation to study because it highlights a universal truth in law, regardless of which country you happen to be standing in. Authenticity is the baseline requirement across all these legal systems.
Right. Everyone wants to know it's real.
Exactly. Every single court wants to know that the message hasn't been tampered with. But the procedural thresholds, the actual hoops you have to jump through to prove that authenticity, are vastly different depending on the country. Bridging the gap between raw data, which is just ones and zeros sitting on your device, and legal evidence that can actually win a case is a monumental process.
Okay, let's unpack this, starting with what the sources reveal about the legal framework in India, because this is where the biggest shocker hit me.
The screenshots.
Yes. The source material explicitly states that while electronic evidence is recognized in court, screenshots alone are absolutely not enough.
Not even close to enough. In India, the admissibility of these chats is governed by some incredibly stringent requirements, specifically under Section 63 of the Bharatiya Sakshya Adhiniyam, or the BSA.
The BSA, right?
The legal system there recognizes how incredibly easy it is to fake a digital image today. You don't need to be a master hacker anymore. Anyone with 10 minutes and a free app can change a text bubble to say whatever they want.
So true.
Because of that reality, Section 63 mandates a highly specific, formal certificate to prove the authenticity of any digital record you want to introduce.
Looking at the visual guide Usman Khan put together, the checklist for this Section 63 certificate is just exhaustive. Let's put this into a real-world scenario for the listener. Say you are in Mumbai and your landlord texts you saying they are illegally doubling your rent tomorrow. You take a screenshot and think you have them dead to rights. What does this certificate actually demand you provide to the judge?
Prepare for a lot of paperwork. You cannot just sign a piece of paper saying, "I promise my landlord sent this." The court demands the deepest device details to anchor that floating piece of digital data to the physical world.
Okay.
First, you need to list the device name and the specific model. Then you have to document the operating system it is running on. But it goes even further than that. You must provide the IMEI number.
Wow. For anyone who hasn't dug around in their phone's settings menu recently, the IMEI is basically the unique physical serial number of your specific phone hardware, correct?
That is the core of it. By requiring the IMEI in the OS version, the court is essentially locking that digital conversation to a specific physical piece of hardware at a very specific point in time. It prevents someone from just saying, "Oh, I saw this message on a phone somewhere at a party."
It ties the data to a tangible object.
Exactly. And along with all of that, you have to provide your phone number and the opposite party's phone number.
And the visual proof requirement is just as strict. The checklist notes that those phone numbers must be physically visible within the screenshots you submit to the court.
Think about how we all use our phones. We save people under nicknames. Anyone can change a contact name in their phone to landlord or John Smith and then fake a conversation.
Right.
The court needs to see the actual routing number, the 10-digit phone number, to establish a factual, technological link between the device in your hand and the individual you were accusing.
That makes total sense. A saved contact name is just a label I created. And on top of all of those technical details, the sources say you have to submit a formal declaration confirming that the chats were taken directly from the original device with absolutely no changes, no cropping, and no forwarding.
The forwarding aspect is crucial. Forwarded messages strip away vital background data. The court wants the raw, original interaction.
I was trying to think of a good way to picture this Indian legal standard. It feels like the courts treat a basic, uncertified screenshot like a flimsy photocopy of a photocopy. It might show you a picture of a document, but without the original book it came from, you have no idea if someone whited out a paragraph or changed a number with a pen.
That is a perfect analogy.
That is why the biggest takeaway from the Indian standard is preservation. The source emphasizes that you must preserve the original device and the chats.
The court is effectively saying, we might look at your photocopy, but you better have the original book it came from ready for us to inspect. And that concept, prioritizing the original physical source over a flimsy copy, leads us perfectly into how the legal framework operates in our next jurisdiction.
So if India is entirely focused on the exhaustive paperwork needed to validate a screenshot, what happens if you bypass the screenshot entirely and just hand over the physical phone? That brings us to how Pakistan handles digital evidence. The sources break down a very different but equally rigorous approach here.
In Pakistan, the backbone of digital evidence admissibility rests on the Qanun-e-Shahadat Order, or the QSO, which was established in 1984.
Wait, 1984? That was decades before smartphones or WhatsApp even existed. How does a law from the era of cassette tapes govern a modern texting dispute?
It is a great question, and it is all thanks to a very crucial legal provision within the law, Article 164. This is what the legal world calls a non-obstant clause. Think of a non-obstant clause, like a legal VIP pass. It essentially translates to notwithstanding anything else. It acts as a legal override that allows the courts to let modern technology skip the line of older evidence rules. It explicitly allows courts to accept evidence generated by modern devices or techniques, even if the older framework didn't anticipate them.
So Article 164 is the VIP pass that gets the WhatsApp chat through the front door of a Pakistani courtroom.
Exactly that. But getting through the front door is just step one. Step two is proving the evidence is genuinely what you claim it is. That brings in the Prevention of Electronic Crimes Act, or PECA, of 2016. Section 35 of PECA is entirely focused on data preservation, which is critical for maintaining what we call the chain of custody.
The sources mention the chain of custody frequently. What does that actually look like in practice for a digital file?
It is a meticulously documented trail. Think of it like a continuous, unbroken receipt for your data. The court needs to know every single person who touched that evidence, from the moment the police or forensic team collected your phone to the lab technician who extracted the data, all the way to the prosecutor presenting it in court.
Wow.
If there is a single undocumented gap in that timeline, a break in the chain, the defense can argue the device was tampered with and the evidence can be thrown out entirely.
And this is where the Pakistani framework draws a very hard line between what it considers primary and secondary evidence. How exactly do those two categories differ when we're talking about text messages?
Under Pakistani law, the original digital trail is the gold standard. That means the physical phone itself, or a pristine, verified forensic export of the data directly from the device's memory. That is classified as primary evidence.
Okay.
A screenshot, on the other hand, is considered a step removed from the source truth. It is merely secondary evidence. It is basically just a rumor of what is actually on the phone.
Which means it is subjected to much heavier scrutiny if someone challenges it. And the sources point to a massive landmark turning point for this in 2019.
Yes, a Supreme Court case known as Ishtiaq Ahmed Mirza versus Federation of Pakistan. This ruling essentially rewrote the playbook. Because of this case, if digital evidence is contested by the other party, if they simply say, I never sent that message, strict guidelines kick in.
You can't just argue about it anymore.
Right. You can no longer just stand in front of the judge and argue back and forth about whether a screenshot looks real. The debate stops. The digital evidence must be proven to be completely free from tampering through a mandatory forensic report.
So the devices are immediately handed over to the forensic analysts. It takes the argument away from the lawyers and hands it to the scientists.
To put it in perspective, it is a strict, unavoidable mandate. The science must validate the claim before the legal argument can continue.
Here's where it gets really interesting. The sources pivot from these South Asian frameworks to contrast them with two Western approaches, the United Kingdom and the United States. And despite sharing so much legal history, their modern approaches to digital data are surprisingly different from each other. Let's start with the UK. I like to call their approach trusting the machine.
It is a very fitting title. In the UK, digital evidence is primarily governed by the Civil Evidence Act of 1995 and the Police and Criminal Evidence Act, commonly known as PECA, from 1984. But what makes the UK system so distinct is a specific legal presumption regarding how devices are authenticated.
Okay, what is that?
The UK operates on a built-in legal presumption that the computer or device was working correctly unless there is specific evidence introduced to suggest otherwise.
That is wild to me. So instead of making you jump through hoops to prove your phone was working perfectly and capturing data accurately, the court just assumes the technology did its job, unless the opposing side can actively prove it was glitching or hacked.
Effectively, yes. It shifts the initial burden away from the person bringing the evidence. But that certainly does not mean anything goes. The UK heavily scrutinizes what the machine produced, even if they trust the machine itself.
Right. They look at the output.
Exactly. For instance, when dealing with the chain of custody, the UK courts focus intensely on the reliability of the software used to extract the data and the actual human being who performed the extraction. They are deeply interested in metadata verification, the hidden data about the data, like exact timestamps and file sizes, and proof of authorship.
And what about hearsay? The sources mention the concept of hearsay a lot regarding these Western systems.
Traditionally, courts universally despise hearsay, which is essentially secondhand information. It is someone justifying, well, John told me that Sarah said this. Courts hate it because you cannot cross-examine the person who originally made the statement to see if they are lying.
But the rules have adapted for the digital age in the UK.
They have. In the UK, for civil cases like a breach of contract or a property dispute, hearsay is generally admissible. You can bring those text messages in relatively easily. In criminal cases, it is much more restricted naturally. But there are established legal pathways to get those messages in front of a jury. This approach, however, is a stark contrast to how the United States handles things.
Oh, absolutely. The USA approach is basically the polar opposite of trusting the machine. It is a system built entirely on strict authentication and deep skepticism. The laws at play here are the Federal Rules of Evidence, or FRE, specifically Rules 901 and 1002, which deal with the requirement of proving the original document.
The American system demands that you prove every single step. Now, the U.S. does have provisions for what they call self-authenticating digital records under Rule 902, Sections 13 and 14, but self-authenticating is a very misleading term.
Yeah, it sounds too easy.
It does. It does not mean you just unlock your phone and hand it to the judge. It requires incredibly strict certification by a highly qualified, specialized technician who extracted the data.
And then there is the hearsay hurdle. When I read this part in the sources, I actually laughed out loud. In the US, electronic messages like a casual WhatsApp chat are often instantly flagged as hearsay by default. So legally speaking, my phone texting "I'll be there in 5 minutes" is treated with the same suspicion as courtroom gossip.
That is the textbook reality. Fundamentally, a text message is an out-of-court statement being offered to prove the truth of whatever is asserted in that message. So just getting the text message into the courtroom requires you to find a specific legal exception to the hearsay rule.
The sources mention one called the party opponent admission exception. How does that work?
If you are suing someone and you have a text from them clearly admitting fault, saying, "I know I backed into your car, I'm sorry," that is an admission by a party opponent because they are the ones on trial. That bypasses the hearsay rule. But finding and applying those exceptions is a very complex legal dance for attorneys.
But even if you get past the hearsay rules, there is an even bigger technical mountain to climb. The most intense part of the U.S. requirement, and where they are arguably the strictest in the world regarding chain of custody, is the requirement of the hash value. What exactly is a hash value in this context?
It is a brilliant, highly complex piece of cryptography. A hash value is essentially a digital fingerprint for a specific file. When a forensic expert extracts a WhatsApp chat log from a phone, they run that entire file through a mathematical algorithm. That algorithm generates a unique, fixed-length string of letters and numbers. That string is the hash value.
The sources emphasize how fragile this is. If even a single thing changes in that file, if someone deletes one period at the end of a sentence or alters one single pixel in an attached photo, the entire hash value changes completely, doesn't it?
It alters everything. The algorithm will generate a completely different, unrecognizable string of characters. It is mathematically impossible to change the file and keep the same hash value. So, in the U.S. courtroom, To conclusively prove the file hasn't changed a single byte since it was collected from your phone months or years ago, the forensic expert shows the court the hash value from the day of collection and the hash value of the file sitting in the courtroom today. If they match perfectly, the chain of custody is unbroken, the evidence is golden. If they don't match, your evidence is almost certainly getting thrown out.
So what does this all mean? We have journeyed through the rigorous paper certificates of India, the primary forensic mandates of Pakistan, the machine presumptions of the UK, and the intense cryptographic hash value mathematics of the USA. If you are listening to this and you rely on digital messaging for your business or personal life, how do you actually handle your own digital data? Advocate Usman Khan provided an admissibility checklist at the end of the sources, an ultimate survival guide for your data. Let's break down those actionable takeaways for the listener.
The first and most absolute rule is preservation. The forces make it undeniably clear. Never, ever delete the original chat. Do not try to clean up the conversation to make yourself look better by deleting a snappy reply you sent.
Don't touch it.
Right. And remember that forensic imaging, which is a complete mathematically verified copy of the device's data made by a professional, is always superior to taking screenshots. If a serious dispute is brewing, your physical phone itself is the most vital piece of evidence you own. Treat it like a crime scene.
The second major takeaway is that context is everything. If you do have to rely on screenshots in the early stages of a dispute, perhaps before lawyers get heavily involved, those screenshots are entirely useless without context. A floating bubble of text means nothing to a judge. Your screenshots must show exact dates, timestamps, and the actual contact information.
No nicknames.
Exactly. Like we detailed earlier with the Indian laws, having a saved name like mom or boss at the top of the chat won't cut it in court. You need to pull up the contact card and ensure the actual routing phone numbers are visible in the image to prove exactly who is talking.
And finally, the third takeaway brings us to the crucial human element, the IT expert. In any complex dispute, an IT expert certificate or live testimony is absolutely essential. Whether it is fulfilling the exhaustive Section 63 BSA requirement in India, generating the mandatory forensic lab report in Pakistan, proving the software reliability in the UK, or calculating those delicate hash values in the US, the IT expert is the bridge. They are the highly trained translators who turn your raw ones and zeros into court-recognized ironclad evidence. You cannot do it alone.
It really takes a village to authenticate a text message.
If we connect this to the bigger picture, it is profound to think about how casually we treat our digital interactions every single day. We fire off dozens, sometimes hundreds, of WhatsApp messages a day. Business agreements are made with a quick thumbs-up emoji. Arguments escalate over typos. Promises are made and broken in seconds.
Yeah, we don't even think about it.
We view them as fleeting, casual moments. But the legal system views them as permanent, highly structured documents. This deep dive really reveals that our daily texts carry a massive, hidden legal weight. The barrier to proving their authenticity is intentionally kept high by courts worldwide. And that isn't to make litigation annoying, it is to protect us. It protects us from living in a world where digital texts are easily manipulated, faked, and weaponized against innocent people.
It really reframes everything on your phone, doesn't it? Which brings me to a final thought for you to ponder long after this deep dive ends. We've talked so much about preserving the device, but think about the life cycle of your physical phone. Every couple of years, you trade it in, you sell it, or it ends up in a drawer. If the physical device is the ultimate primary evidence, the original book, as we called it earlier, what happens to your legal standing when you mail that phone back to your carrier for a discount on the newest model? Who holds the metadata then? How might knowing that a court could one day demand your exact physical device just to verify a simple text change the way you hit send or the way you hit factory reset today? Thank you for joining us on this exploration into the hidden legal framework of our digital lives. We will see you on the next deep dive.